Welcome. I'm Russell Alexander. I've been practicing family law with the team here at Russell Alexander Collaborative Family Lawyers for over 20 years. We serve clients during separation and divorce and other related family law matters. We upload a new video twice a week to cover off interesting cases and provide up-to-date information for our clients and the public, including cases about the pandemic. Today we're going to discuss, does having a criminal conviction block a potential parent from adopting? Recently, the New Brunswick Court of Appeal had an interesting issue to resolve. Does a fraud conviction by one member of a couple preclude them from adopting a child? In this case, the child had been in the couple's care since birth under a foster care agreement with the relevant government ministry. When the parents applied to formally adopt the child, it was revealed that the mother had been convicted of fraud under $5,000 in connection with her previous employment. She received a 10-month intermittent sentence under provincial legislation governing adoptions in the province. The minister was obliged to assess the couple's suitability as prospective adopted parents. However, a criminal fraud conviction was one of the expressly listed indicators of unsuitability. So the minister advised the parents, essentially on an administrative basis, that they were out of the running for the adoption. The couple applied to the court but failed to get the minister's decision overturned on review. They appealed to the Court of Appeal. If you're enjoying this video and find it helpful, you can give us a thumbs up or leave us a comment below. Looking at the wording of the legislation at the Court of Appeal, the couple argued that the ban against having a criminal conviction was not mandatory. In other words, they could still be considered suitable prospective adopted parents, even despite the mother's criminal record. In other words, they argued that the minister was allowed some discretion in this regard. They also argued that the child's well-being had been overlooked. The prior judge had failed to consider the best interests of the now 18-month-old special needs child who had been in their foster care her whole life, and with whom it was conceded they had a strong and loving bond. In fact, the putative parents argued that they were not only the best interests of the child as be considered as part of the suitability assessment, they were the paramount consideration. Despite these arguments, the New Brunswick Court of Appeal nonetheless dismissed the couple's appeal. The goals of the pertinent legislation were clearly aimed at child protection and fostering the best interests of the child. The Act listed the specific criteria that were to be considered when declaring prospective adopted parents to be unsuitable. Certain criminal convictions were among them. Once the mother was convicted of fraud, she met the threshold criteria. The minister was not at liberty to declare otherwise. The legislation did not leave room for any discretion nor for any exceptions. The appeal court noted that the court clarified that the minister was indeed obliged to consider the best interests before placing her for adoption. But this consideration was to come later and did not override the initial threshold test for suitability, which was set out in the Act's listed criteria. Please leave your thoughts and questions in the comments below. If you liked this video and found it helpful, please give us a thumbs up or let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.